Good afternoon and welcome back to Law and Crime Network. I'm your host, Allura Nanos, for this lunchtime hour, and we're watching the Todd Kendhammer trial going on live right now in Wisconsin. And I am joined today by former prosecutor and current defense attorney, law professor, Miami-based Mark Eiglarsh. Mark, nice to have you with us today.
Thanks for having me on again. I appreciate it.
Absolutely. So this case, we have something here that we don't have in most trials, which is a defendant on the stand. For those of us who like to watch trials, the idea of having particularly a homicide defendant testifying on the stand, it's a big deal. It's what we kind of all wait for all the time, and we rarely get the opportunity to actually see that in action. So I really just want to start there. As an experienced attorney on both sides of these kinds of cases, what are your thoughts about even having that defendant on the stand?
I'm livid. Does that say it well? I'm livid. Let me explain something to you. I rarely ever put my clients on the stand. That doesn't mean that they're all guilty, but you've either got the case won or you don't. Let's look at your sample jurors, who are the people, your wonderful watchers. I've been watching all their comments as I've been waiting. And most of them either feel that the state hasn't proven their case, or a majority believe, this guy is probably guilty, but you don't then put him on the stand and further evidence to help the state. You understand? Either the defense has done a good job in discrediting the state through their experts, and they'll continue to do so through the series of 45 witnesses, but you don't put the defendant on. It's too risky.
And I would think, Mark, I agree with you there. And in a case like this, where there is no eyewitness to the crime, and essentially, the guilt or innocence of this defendant is going to be determined by a series of experts and forensic evidence, and basically everyone trying to recreate the crime scene for jurors. This seems like the worst possible type of case to have. Whenever we have a case where a guilty verdict really depends on the state recreating that crime scene, there's always going to be the possibility that they just didn't do a good enough job, where the jurors can say, well, he may have done it, but the state really just didn't convince me enough. But here, there seems like an awful lot to lose by having this guy in the stand.
Yeah, not to mention, he spent hours in a room with them. I would say my client has nothing left to say. He said it all when he said not guilty. We're done here. Now you're going to put him back in front of the jurors, let the prosecution grill him. Yeah, he's going to do his best on direct, but then now you're turning this case over, your client's liberty for the rest of his life, to prosecutors who are going to make him look however they want to make him look. You can't control that. It is the worst feeling as a trial lawyer, and I say you do it only when you have to. And quite frankly, by have to, it means that I'm losing this damn case. Client wants to take the stand? Sure, go ahead. See if you can convince them.
Well, let me just say this. So ultimately, though, the decision about whether or not a defendant testifies in his own defense is not actually a decision for the attorney to make. It is the one decision that the client himself gets to make. So it is possible that in this case that the attorneys did tell him, do not testify. It's very possible that as experienced defense lawyers, Kendhammer's lawyer said, don't testify, it's a terrible idea. And he may well have insisted that he get to take the stand.
Yes. However, I've stopped counting after 150 jury trials in 25 years, in spite of my youthful appearance. Thank you. But one time, maybe I had someone with tremendous defects in character or such psychiatric issues that he didn't value my opinion and chose to take the witness stand. It really didn't matter in that case anyway. But most of the time, that's what you're paying for. You're paying for my trial experience, my knowledge, and yes, it's your decision, but my opinion better weigh heavily, or else this really isn't working.
So in your experience, if you've told clients, hey, don't testify, it's a terrible idea, most of your clients will have listened to you on that piece of advice.
Of course. I explain to the client how they just have to prove their case. If they don't do it, you don't have to get up there and try to make them like you. Listen, the odds of even you're an extremely likable person, the odds of putting together 6 or 12 random people who are all going to like you is extremely rare. And if they don't like you, they're going to nitpick like your viewers have been nitpicking the heck out of this guy. I mean, even things that are innocuous, they're going, oh, I don't know, I don't believe
That's
that.
right.
That's what jurors are doing if they're not in your favor. Why do it unless you have to? You've got experts, you've got the guy already being grilled, you've got his testimony, they heard how he sounds. I don't like it at all.
Yeah, that makes good sense to me, although I have to say I am fascinated by you having all clients that take your advice, because clients in general, they sometimes take advice. They often do the opposite of what you've told them to do, at least in my experience.
Listen, I don't want to take anything away from your viewers. As a viewer, this is wonderful. I mean, This is it. This is the moment you wait for, to have the defendant speak. I'm not saying anything. This is great for Law and Crime. It's great for my buddy Dan Abrams. It's great for everybody that the guy's taking the witness stand. I think it's fabulous.
Just not good for him.
But what's that?
Just not good for Todd Kendhammer. Yeah.
It might be. Let me stop you. It may turn out to be okay with him. So understand, it could be a not guilty. But here's my problem. You don't, as a trial lawyer, I like to control everything. I'm telling you, every gesture my client's making in court, every movement, every interaction is as controlled as it can possibly be. Every note he's taking, I'm watching him, and I'm watching the jurors watch him. It's that choreographed. It's that thought out. Now you're going to take this guy and throw him up there and say, hey, prosecutors, have at him. Oh, no, we've prepped him. He's going to do well. Don't worry about it. Maybe he will. Maybe he won't. Why take that risk?
Yeah, no, I think that's a really good point. So I want to shift now to looking at his testimony. So we're in the middle of direct, maybe toward the end of the direct testimony right now. How do you think he's doing? As I'm watching, I'm thinking there's really so much time that was spent during this testimony on having this guy recount his day-to-day relationship with his wife. They talked about their finances and how they would eat ice cream and watch television together. What did you make of that? What did you make of the amount of time spent on it, and whether and do you think that Todd Kendhammer as a witness is a credible witness at this point?
All right, so those discussions that you find to be like, why are they bringing that up? It's all first and foremost something that the state cannot impeach. So you've got all that stuff. Only he knows what him and his wife did, and the state's not going to impeach him on that. So you're at least establishing rapport with jurors. You're all that stuff they're listening to. They're finding, I guess, credible because it won't be impeached. So that's good. You want enough of that to draw jurors in, to get them to believe that this is how their life was. And ultimately, they're trying to convince these jurors that this relationship was kind of unnatural. And by that I mean I have probably one of the most loving relationships that anyone has. And to suggest that I haven't raised my voice to my wife or she to me is ludicrous, right?
We were just having that exact discussion here off camera, saying that the exact same thing, that is a bizarre statement to make while testifying, where what
Right.
you say can't be precise enough to say I've never raised my voice to my spouse.
Right.
Just seems weird.
But to get them to believe that, and that thus there's no motive, and they had the perfect tofu vanilla relationship with no rocky road and nothing that would be problematic, for them to pull that off, he's got to kind of explain what their life was like, and I don't know, maybe it's true, maybe it's not. None of what he's saying is going to convince me one way or another. No one's going to score a knockout blow one way or another. That's why I don't think it's worth it for the defense to put him up there, because you risk that one thing where a juror, rational or not, says, I didn't like the way he answered that. There was not enough emotion. I would never talk about my wife like that and this and that. You just can't please every juror. I don't like it.
Now, what about this issue? Under the law in this state, there is no need for the proof of any particular motive in order to get a first-degree murder conviction, right? But of course, human nature being what it is, when any of us, a juror or someone outside the courtroom, are sitting and watching this, we sort of want to know, well, why? If we are convinced, in fact, that this guy committed the crime, there's this natural longing for an answer to the question, why did he do it? In terms of the prosecution side of this, they can really gain something here from making something out of Todd Kendhammer's testimony and creating something of a motive out of it.
Yes.
How do you think that's going to go?
No, I love it. And I didn't even think about how, that was a brilliant point, okay? Not that it was unexpected. That was absolutely brilliant. I just hadn't thought that it goes to the motive. Think about that. I said last time I was on, the biggest problem with the state's case is motive, right? We don't know. We have no idea what was going on in that guy's house. Either was as loving or as vanilla of a relationship as he's alleging, or there was something going on that was ugly and dark and that caused him to do this horrible crime. We don't know. That's the biggest problem with the state's case. The only way that they're ever going to develop that, possibly, is through him being up on the stand and somehow giving some insight into jurors' minds as to why he might want to do this. Again, too risky. Best thing you got, state, no motive.
Yeah, I agree with you on that.
Excuse me, what the defense has that's great is no motive.
Yeah.
And you're right, by the way, I don't know of any state that requires a motive because you never really know why someone kills someone.
And ultimately, it doesn't matter from a legal point of view why they did it. It only matters that they did it.
Yes, but in a case like this, where you're suggesting it was for some other reason, it was a freak accident, then you got to go, well, wait a second. To overcome that, we'd like to have a motive. Some jurors may say, I don't know, I just don't see it. I need a motive.
Yeah, yeah. I have one more question that it just kind of struck me, and I'm having a hard time myself sort of getting past it. And here it is. What are the odds that in a case that so much depends on this whole issue of the windshield? Did the pipe come through the windshield, or did he hit the windshield? Everything with the windshield. Doesn't it seem extraordinarily coincidental that this guy is in the windshield business? There's something about it that seems weird to me.
Yes, that is bizarre. But any more bizarre than a pipe coming through your windshield? I mean, that's bizarre. There's a lot that this guy never raised his voice allegedly, or the fact that he's saying that he didn't.
Right. The whole thing is weird.
It is weird, but is it proof beyond a reasonable doubt? That's a whole nother thing.
Well, I certainly agree on that point. I think that this is going to be, these cases tend to be so difficult because there's really kind of no reason. Nobody is going into these kind of cases. There's no factor that appears on the surface that would sort of bias the average reasonable person one way or another way. Whereas with other cases where, for example, the defendant has a long criminal history, or where there's an obvious motive, or the victim is involved in a violent lifestyle or whatever, we just don't have any of those things.
One thing that sticks out. Can I jump? Just one thing that struck me, and maybe that's why they're putting him up there to explain it. The one thing during his interview that got me was they asked him, well, then how did she get all those injuries? The ones unrelated, like to the back of her neck, unrelated to a pipe allegedly coming in. And his answer, I don't know. And yeah, he wouldn't know, I guess, but that's also the answer you give when you can't explain it away. When, okay, cops, you got me, that's troublesome to me. But again, as long as some of the experts or he or somebody explains that away. In fact, there was an expert who said because her head was in a down position like this, that it caused something. I mean, I have no idea if that's crap or not, but you know what? As long as it explains it away, that could negate the state's burden.
Yeah.
It could be like, they didn't make it. It's not there. Yeah,
well, we'll see. Mark, thank you so much for your commentary today. Love to hear from you. We love having you on. I hope to be with you again soon. I know you have to go, so we will see you again soon and hopefully be back before the end of this case.
Take care. Thank you.
Thanks so much, Mark. So we're going to get ready for our next guest, and while we do that, we're going to just play a quick clip going back to a little bit of Todd Kendhammer's testimony in case you missed the beginning of that testimony. We do have some real interesting moments that we will be back to talk about in a bit, but for now, here's back to Todd Kendhammer.